You can dictate the court proceedings and what kind of judge you're going to get and what kind of rules they're going to play by. And it won't be the regular rules because, again, trusts are a special thing.
The so-called pure trust, also known as the constitutional trust or the common law trust.
When we write these trusts and we send them to the government, we give them 30 days to disclaim. So we give them the opportunity to say this is fraudulent or this is wrong.
The IRS determined that the trust should be disregarded.
Brandon did mention that he tried to read Art of the Passing Buck, Book 1, and he dismissed researching who these individuals behind the trust were that wrote the book.
Imagine being the guru saying all this, and then you're literally dealing with what you said wasn't possible.
They defended that book against the IRS, and I believe the Department of Defense.
The IRS determined that the trust should be disregarded. The total amount of tax deficiencies assessed in these 4 cases involving Wyckoff and Ozak's promotion of common law trust is
just register everything in the trust and there isn't going to be a problem. When you don't have to pay taxes and you get 100% of your check, boy, let me tell you, that's a whole different game.
And this is a real life example of someone trying to do this.
I can't tell you how many issues I've had with clients that have set these up, that have bought properties with them, they go to sell them, no one knows what the hell it is. The title company's like, what is this? This state doesn't have business trust. I know it's a Delaware business trust. Okay, but you're in California. They're like, yeah, we don't recognize that here. They wouldn't transfer the property. The person had to unwind the whole thing, deed the property back to the person they bought the property for, have them deed it back to them.
So when you ask an attorney, they're probably going to say, I have no idea what you're talking about. That doesn't make what I'm doing wrong.
Sovereign Citizen Trust Guru, KL Mr. Beneficiary, has responded to my investigative video that we did on him a few months ago, and I want to talk about it.
She signed it as Rosalind Ray Keenan Beneficiary.
Some of you may know about the sovereign freeman tax protester movement.
Makes you liable to pay taxes. That's because you signed an agreement and said you would. So if you undo that contract, guess what? You're not liable anymore.
KL Mr. Beneficiary is one of the many gurus selling dreams that we uncovered to be problematic. After our investigative video came out, he went on camera recently to try to do a rebuttal for damage control. He doubled down on talking points that I uncovered and will outline to be outright pseudo-legal fiction. So let's compile a list of sovereignty or trust guru red flags. 1. My trusts are private, not public. Another thing, private business trusts, unincorporated business organizations. Not using trust for what they're actually useful for, which is estate planning, disaster protection. Private trusts get you out of taxes. My trust is under the law of equity and not statutory legal system. Court cases are trusts. Almost everything is a trust agreement. Another red flag, sources used to back up their claims have nothing to do with the said subject or grossly subjectively misrepresented. Another one, misrepresentation of legal terminology, of obscure or misinterpreted legal terminology and historical references to advance their claims, which are typically rejected by the courts and not recognized as a valid legal argument. Lack of legal foundation. Legal systems are based on statutory and common law. Courts reject arguments that are not based on recognizable legal principles, statutes, or case law. Arguments rooted in obscure or non-existent legal doctrine, like what Kale loves to reference, the 12 presumptions of Roman law. We're going to go through every single one of these red flags as all horseshit snake oil. There are basically 2 kinds of trusts, public and private, end quote. Well, this is a false dichotomy in the way that these gurus present public and private trusts, what they supposedly are, and the differences. Did you know all trusts to benefit individuals are private by default? Revocable trusts are the most popular nowadays. They usually have the grantor as the trustee, and the trustee is usually listed on public things like deeds, accounts with third parties like banks. So a typical living trust or irrevocable trust is a private express trust by default. Just about any trust created to hold assets for a private beneficiary qualifies as a private trust. So there's nothing special about saying that my trust is private, yours is not, like these guys say. An irrevocable trust, that has a separation from the grantor and the trustee. So in a way, irrevocable trusts are more private in that sense. But there are no databases or form filing for a private trust in the Secretary of States for this kind of trust, right? We'll later go through, there are kinds of trusts where you do that, but it's not what these people are talking about. Any individual looking to form a trust for their family's benefit, by default, has a private trust. Now, if you want a charitable trust, that is what's considered a public trust in law. So, under the charitable purpose doctrine, a charitable trust must serve purposes of, quote, of such social interest or benefit to the community, end quote. The courts police the requirements of charitable benefit by insisting on objective criteria for determining what constitutes public benefit. Nowadays, they use UTC, Uniform Trust Code, subsection 405A, to uniformly define this. You can see how the gurus create this fiction of how they interpret what a private and public trust means versus what actually defines the two according to the law in courts. So guys, this is an example of cognitive dissonance. They tell you to forget what the laws, the codes, the statutes, and the courts have to say.
Not liable for any state code, statute, or act.
All right, so now the business trust. Now KL doubles down on his, what he calls a private business trust, which again, we've already debunked the whole private trust thing. Legal entity that technically owns a business, sure. But that's just describing the purpose of the use of the trust. Not all of them recognize a business trust, okay? They're mainly on the East Coast, and it is for actual corporations' use, these types of business trusts I'm about to cover. They have nothing to do with individuals trying to set up their estate plan. Quote, the business trust is an extension of the traditional trust. Boom, there you go. In a business trust, as in a traditional trust, property is conveyed pursuant to a trust agreement to one or more trustees for the benefit of a defined group of beneficiaries. Okay, so there you go. Many states in the U.S. have passed statutes regulating business trusts. Therefore, these business trusts are more accurately referred to as statutory business trusts. Okay? Business trusts, as they are actually for real estate investment trusts, mutual funds, ETFs, asset securitizations, etc. That's how they're used mostly nowadays. So it's mostly for having trusts available for outsiders to invest in, right? And we'll later go through what that looks like. So he tries to say that his private business trusts are unincorporated business organizations. Now, if the grantor, beneficiary, or trustee materially participates in the operation or daily management of the business, if the grantor remains control of the trust, then the grantor trust rules apply. Otherwise, the trust would be treated as a simple or complex trust, depending on the trust instrument. So a true business trust can't be taxed as a corporation, association, or an individual. It is to be treated as a corporate entity as far as tax treatment. Whether you file taxes or not, that is up to you. But really is how the IRS sees it, rather than just blindly believing some a-hole on the internet saying that you will never have issues with the IRS using their strategies. Just go on the IRS's abusive trust scheme page that we went over in the last video, and exactly describes everything these trust gurus are talking about. Look how it ended up for all these tax protesters. That type of strategy failed the Art of Passing the Buck authors, and we're going to later show you the real life case of that. So he doubles down the private business trust again. He says, quote, private business trusts are under the jurisdiction of the law of equity, which is not under Title 26, U.S. Code and statute, end quote. Look, like Clinton and I said on our last video, states have adopted the Uniform Trust Code, which is under statute. No matter what you call your trust, trusts are statutory and under Uniform Code. Trusts are persons legally. Go look in any state statute and you will see that reflected. So he is completely disregarding what the law actually says. Also, remember how he calls his private business trust an unincorporated business association? Well, same thing. Go look in any state statute. An association is a person. He says private business trusts are not under Title 26. But yet, the IRS code clearly spells out how business trusts are, yes, in fact, taxable as a corporation. Okay, so we can look at Morrissey versus Commissioner. You'll see on this page here all the past cases relating to this issue of business trusts being taxed. So here we go. Holding that a business trust should be taxed in the same way as a corporation because of their similarities. Summary of this case from Fox versus Prudent Resources Trust. Another one, explaining that common law definitions of certain corporate forms do not control interpretation of federal tax code. Summary of this case from Littriel versus U.S. Morrissey, the question was whether a trust created for the development of a tract of land was an association under federal tax law and hence taxable as a corporation. Summary of this case from O'Neill versus United States. Then he goes on to say, quote, stating only a revocable trust can have a grantor, end quote. So this was him misquoting Clinton I, saying that only a revocable trust can have a grantor. And then he goes on to say that both a revocable and irrevocable trust have grantors. That's Trust 101 basic information. And you see, this is showing Cale's willingness to lie and exaggerate things and misquote us. Actually, him not knowing what we were actually talking about, and I'm going to give you the full context, shows Cale's ignorance of what we were actually talking about. Clinton and I were talking about grantor trusts versus non-grantor trusts. What are grantor trusts? What are the differences between these two? Well, grantor trusts are controlled by the grantor.
We have these rules that are called the grantor trust rules that would prevent someone from creating a trust for themselves and in many cases for their family because they like to keep control over these trusts and then not paying tax on it. So what happens is you put the money in the trust, say you're a beneficiary of the trust, and you think, oh, great, now I don't have to pay tax on the money, even if you got over this assignment of income issue. Well, the answer is not so fast because the grantor trust rule pretends that you still own what is inside the trust and therefore you still own the income and therefore you pay tax on it.
Quote, trusts are adjudicated in the courts of equity, not in the state district courts. And this is him continuing. It's a long rambling. He says, okay, so if you can get a judge to see that this is an actual trust going on here, whether or not you got a piece of paper, just by the implication of what people are doing in Article 3 judge, what people are doing, then an Article 3 judge has to adjudicate it as a trust, not Article 1 judge. And they're going to see, you get to be seen through a different set of rules. Okay, so we're later going to present actually how someone used this, exactly what he's talking about. They tried to use it in court, and it failed. It didn't work. They lost the case. So anyways, we'll show that later. It's a real-life court case, which, by the way, is a guru of KLs. You get seen through a different set of rules, which we call equity rules, instead of the statutes and codes. And everything depends on your actions, not some code that a lawyer is going to pen up. So it does make a difference in understanding this and having remedying solutions in court that are actually for the private American or natural person. And later we'll debunk those two things as well. You cannot get to those until they see a trust going on. End quote. Another quote. I'm a beneficiary of a trust. That's what's going on here today. And if I'm the beneficiary and that guy over there is the trustee, I have an equitable interest in this case, and thus I need to see this in front of an equity judge.
You can dictate the court proceedings and what kind of judge you're going to get and what kind of rules they're going to play by. And it won't be the regular rules because, again, trusts are a special thing.
And they can see that that's where your remedy is in court and getting them to see the trust. Otherwise, you got a small chance of winning, but it's very slim to none. You learn the rules of the game. It's amazing how many cases you can win. It doesn't matter if it's a credit card debt, a mortgage you didn't pay. It doesn't matter. End quote. So again, he's talking about his little implied trust strategy. Oh, you just got to claim that you're the beneficiary, have the judge recognize it, and boom, case is won. Doesn't matter what type of court case you're in, you can do that. But again, remember how he says, I'm the beneficiary of the trust, the judge is the trustee? Well, implied trusts, again, they don't have trustees. Oh my god. I mean, there's so much to unpack there. Right? So where is the evidence that what he was just talking about has worked not only for himself, but any of his students. That's what he calls his customers, his students. Such a condescending thing. Any court cases to show from you guys that this is actually recognized in court? When you say all this to the judge, they're like, oh yeah, okay. No, we've actually seen the complete opposite. I'm going to go through that later. But we got a lot to get through. Okay, so he says trusts are under laws of equity. So this is him showing his complete ignorance of how equity court actually works. Now, I did an extensive review on how equities work, quoting the law and legal definitions in that video. Equity courts are not this magic thing like the gurus promote if they actually did their due diligence. In fact, it is something that can work against you, especially with the misguided techniques from these gurus. Now, I'm not going to repeat myself on here too much about equity court, but if you want a deep dive on how equity court works, going off of primary sources, not opinion, check this video out. It's going to be linked below in the video. So, now notice, so this is the thing about equity court. I'm just going to give you the quick summary. The United States and every court has incorporated the two courts, so the court of equity and the court of law. Every court in the United States has combined the two and merged them into one. So, no, there is no separate equity court away from court of law in the states. They are one and the same. So every judge is making decisions thinking in the context of law and equity. Think of them as layers of deductive reasoning. So it is myopic to say that one court is not part of the other. And then we have something called the adoption of the Federal Rules of Civil Procedure that rolled out in 1938. This merged law and equity into a single civil jurisdiction and established uniform rules of procedure. Now, some cases don't have set precedents to them, okay? So you can't just find case law supporting it, so that's where the judge has to rely on the equity side of the equation, making a decision. Now, equity and justice are the means of a balance. Equity is appealing to the emotions, the ideology of the judge, which, let's face it, if you have a woke judge or they got a thing against you, you're really not going to see equity in the same way that they do. The same judge is hearing a law case that's hearing an equity case as well, right? So, court of equity means the judge is the law. The judge gets to decide what's fair, not you. Now, typically, the types of issues handled by equity courts include contract disputes, injunction applications, lawsuits, name changes, issues dealing with adoption, any type of family court stuff, workers' comp. Now, a common type of equitable remedy is used in the case of unique goods called as specific performance. In this type, the court orders the breaching party to fulfill the exact terms of the agreement. So, for example, if you run an art gallery, it's contracted to display a piece by a well-known artist in an upcoming exhibit. However, the dealers doesn't deliver the piece, let's say. That court can then order the dealer to produce that exact piece of art. And then also, they, like I said earlier, family court is equity, so that's divorce. And then they also have administrative estates, conservatorships, and wills. So that's the kind of thing that's in equity court. What does this have to do with anything Kale's talking about with equity? No, you cannot use what he's talking about in court. The court will never see this as a trust. And you trying to get actual equitable remedy and relief only works for certain situations. Not every court case and not every time you get in trouble. So there's a difference between contract law and trust law. Now, a lot of these trust gurus try to say that they're the same thing. Contracts, trust, same thing. Not. Trusts are in equity. Contracts are creature of law. Why do you think they ignore prenups in family court? Because prenups are contracts. Creature of law. The perfect example of this is, well, Kevin Costner's divorce case, Dr. Dre's divorce case. They had what they thought was a bulletproof prenup, which is a contract. So, in divorce court, which is equity court, no, they don't recognize contracts. Okay, so then he tries to say that titles like offices of duty are implied trusts. He then takes the Black's Law definition of implied, but then he tries to add in subjective interpretation of it and tries to apply it to the macro of the legal court system. But then that lacks actual evidence to substantiate his claims that offices of duty are implied trusts, or anything that he says is an implied trust. He can't actually back that up. Does he bother to mention also what an implied contract is? Oh, no. He doesn't want to tell you what an implied contract is. He only talks about implied trust. And by the way, him pulling up the definition, the legal definition implied, there are also implied contracts. So to apply the definition of implied to implied trust, let's look at the definition of implied trust. An implied trust is a special type of trust that is not specifically created by written or spoken agreement. Instead, becomes effective due to particular situations or actions, often to ensure fairness or prevent the occurrence of fraud. Two types of implied trusts are constructive and resulting trusts. Okay, so we'll later go through the two categories of a implied trust. All right, so a resulting trust is an equitable reversion that arises by the operation of law. Whenever a person has created an express intentional trust, but the express trust fails or does not completely dispose of the trust property, the undisposed property goes back to the settlor in a resulting trust. Example, purchaser fails to give a seller agreed consideration in exchange for receiving property. Beneficial interest in the property results back to the seller. All right, so what is a constructive trust? Which again is the second form of an implied trust, which again has nothing to do with what Kale's talking about. A constructive trust is not an actual trust by the traditional definition, but a trust created through a court's power over assets they determine a party cannot equitably keep. It is a legal fiction that is used as a remedy for unjust enrichment. Hence, there is no trustee in a constructive trust.
Is no trustee.
Oh, you're going to want to hold on to that. Kale often says, well, court cases are implied trust, become trustee, and make yourself beneficiary. But here we go. If you actually look at the legal definition, there is no trustee in a constructive trust. But the constructive trust orders the person who would otherwise be unjustly enriched to transfer the property to the intended party. Now, no formula exists to determine when conduct justifies the creation of a constructive trust, although common themes include stolen property, property obtained through a fraudulent means, or property mistakenly delivered to the wrong party. Additionally, a constructive trust will not be created if another adequate remedy exists in law. All right, so whether we're talking about resulting or constructive trust, it has nothing to do with most people. Now, constructive trust is not only for an equitable remedy. If someone wronged you and you win a ruling, a judge can make the equity go to your constructive trust, but nothing special or practical about it. 99% of people, right? This doesn't matter. So you're talking about a trust that would be administered by a court. How is that private? All right. Or even, how is that in your control? A constructive trust example, let's say John embezzles 25 grand from Sarah and uses these stolen funds to put down a payment on a house. Sarah sues John, and the judge finds him guilty. Aside from the criminal charges, the judge orders that John sets up a constructive trust. When the trust is set up, the ownership of the home is transferred to the trust. John no longer is the owner. The trust protects and preserves the home for Sarah since it was financed using her money. Now the trust serves as a holding place until resolution is reached. Sarah will be repaid the original 25 grand, or she may receive the deed to the house. Earlier we explained that the victim can receive back the value of what was stolen, plus any value that has appreciated. Once the wrong is righted, the constructive trust is terminated. A judge that imposes a constructive trust does not intend for it to last indefinitely. They will typically impose an equitable remedy agreement and then order the defendant to take action. So once the victim, the plaintiff, is properly reimbursed, which are created through an act of law after a case has been presented, constructive trust is used as a civil remedy tool that enables a plaintiff to recover their property or damages from the defendant. If the defendant were to keep the contents of the trust, they would be unfairly enriched. In contrast, a resulting trust is dictated by a judge based on the conduct of the parties that are involved. Implied contracts are legally enforceable promises of mutual assent to be bound. See UCC subsection 1 through 201. Now, implied contract which does not have explicitly stated terms is still found to exist because parties assume the contract existed based on conduct. Alright, so let's go through what's called an implied in fact contract. If a customer accepts services from a merchant or gets products from that merchant, then they should pay for the reasonable value of services or products. However, under some circumstances, even if the defendant has received nothing of value, the implied in fact contract can still be enforced. Implied in law contract, which is sometimes referred to as a quasi-contract. It is not only applied when there is no contract, but also applied when there is a total breach of contract. There are no requirements for the meeting of minds or mutual assent. That's a lot of things gurus try to say, well, there was no meeting of the minds, this makes the contract fraudulent. Well, no, here we go. This is an implied in law contract. No requirements for meeting of minds or mutual assent. To imply a quasi-contract as a method of recovery, the measure of recovery is not the contract price, but the reasonable fair value of the benefit conferred. These things that a lot of the gurus say, they're actually implied contracts. Here's another quote from KL. Quote, "The grantor gets to decide on what form of law the parties of the trust abide by." This may sound nice. Some people could misconstrue it. Can the grantor decide if it's a grantor or non-grantor trust? Absolutely. Can the grantor decide on where the trust will be situated, what states it's going to be in? Sure. But it doesn't mean that, well, now the grantor can just say, well, my trust is not under federal or state jurisdiction and statutes, codes, blah, blah, blah. How could he argue that successfully in court? And the answer is he can't. Where's the proof that this has worked? We can look at this, where the grantor gets to decide on the form of law. Well, there is truth in it. The grantor can decide, is this going to be a statutory business trust? So, like, if I'm looking to start, like, a investment fund, say investment trust, let's say, or I'm starting to try to ETF, then sure, the grantor of that trust can then decide to, let's use an example of a Delaware statutory trust, which doesn't relate to the trust that most people are talking about when estate planning, right? This is a very different thing. We're talking about investments that are available for outside investors. It's really business, okay? It's not what this KLO is talking about. Any trust created for personal estate planning is a common law trust. The S&P 500 ETF called SPY, or the Real Estate Investment Trust, the Delaware Statutory Trust, that's going to be a statutory trust. Later, you're going to go through what that looks like. It's not what these gurus say. So these gurus, they try to say that their trusts aren't statutory. Okay, so I was reading through South Dakota trust laws, and it says here, the legal system in the United States, including South Dakota, is based on English common law, and trust law is a matter of state law. The asset protection laws of South Dakota are codified under the Qualified Dispositions in Trust 21, which set out the statutory requirements for a qualifying asset protection trust. And by asset protection trust, they're talking about an irrevocable trust, as well as the fraudulent transfer rules. Because I don't use these gurus' secret trust processes and paperwork, it doesn't mean all of a sudden my trust is a statutory or public trust like they say if you don't use their stuff. Again, all states have statutes and or codes on trust. They have spun the statutory trust, meaning the gurus, has spun the statutory and public trust thing into an artificial pain selling point. And it's a false binary to convince you that their trust is special. You can only go to them. When in fact, their spin of the public and private statutory trust is completely false. A public trust, an organization that manages money for a particular charity or group of people who are poor or in need of help. Yeah, again, that's a charitable trust. That's a public trust. Not what these gurus are saying. Private trust, a legal arrangement in which you give a person or an organization the right to manage your money for the person or group of people that you have chosen to receive the money. He goes on to quote a legal definition of a business trust, which says a legal trust set up for the purpose of business. It may be referred to as an unincorporated business organization. So it's not meant for family inheritance purposes, which is most people's situation when they're looking to form a trust. If I have a business, I can use a regular, revocable, irrevocable trust to hold the equity interest in a business entity like an LLC, okay? Instead of having me as the individual. Although for the most of the time, I recommend that you use an irrevocable for that purpose. But anyways, I cover that plenty in my other videos. So every trust that we're talking about is a trust founded under common law when it comes to most people, right? So what you can do is form a trust under statute, but again, that would be if I'm looking to start an investment fund that's available for outside investors, an ETF. Now, some states such as Delaware have this as an option. I'm not saying this doesn't apply to most people. Again, let's look at the definition of a statutory trust. A statutory trust, or oftentimes referred to as a business trust, and will be used interchangeably throughout the summary, is a form of voluntary business association created by a trust instrument pursuant to which property is conveyed to one or two or more trustees for the trust itself to hold and manage the property for the benefit of the beneficial owners. The modern business trust itself, developed in Massachusetts to avoid the statutory provision prohibiting corporations from dealing in real estate. See Minkin versus Commissioner of Revenue. So common law trust principles, restructuring the ability of trustees to delegate powers, act beyond the terms of the trust instrument, or engage in transactions with the trust, is going to lead to possible non-recognition of limited liability of the beneficial owners, including an imposition of a control test. Potential non-recognition of the business trust as an entity entitled to transact business, possible restriction on the ability to protect trust property from creditors of beneficial owners, and unfavorable tax treatment. Risks of using non-statutory common law business trusts. Several jurisdictions impose a control test to determine shareholder liability, i.e. personal liability is imposed and the trust is disregarded. When shareholders exercise too much control in the management of the trust, which, again, these guys teach, Williams versus Anhibis of Milton, you can also see Frost versus Thompson if you want to read more about this, a real-life example. Here, beneficial owners retain control over the trustees. The common law business trust fails, and shareholders will not be entitled to limited liability. See First National Bank of New Bedford versus Chartier. Common law business trusts were also not always successfully able to obtain the desired tax advantages. See Morrissey versus Commissioner. Common law business trusts, which possessed corporate attributes, were held taxable associations rather than property held in trust. Several statutes in the Delaware Code include the term business trust in definitions of person, just like any other state. Statutory trust, let's look at the definition of that. So there we go, an instrument in the filing of a document with the Secretary of State. Again, private trusts don't file with the Secretary of State. So that just debunks these gurus saying, well, if you don't use me, you're going to get a public trust, a statutory trust, and you're going to have to file, blah, blah, blah. Again, here's telling you what a statutory trust actually is. It's not what these gurus are saying. Now you can see the Delaware Act, for example, and what it says in subsection 3801A. Common current uses of business trust. Asset-backed securities transaction. Collateralized mortgage obligation. Real estate investment trust. Leveraged leasing transaction. Mutual funds and investment companies. Liquidating trusts. Private investment funds, joint ventures, strategic alliances. Trust preferred securities transactions. So again, nothing what these gurus are talking about. Now, a Delaware statutory trust is a legally recognized trust that is set up for the purpose of business. It may also be referred to as an unincorporated business trust or UBO. So there you go. Remember how he tries to say that his private business trust is an unincorporated business trust? Well, if you actually look at what unincorporated business trusts are, UBOs, they're referred to as Delaware statutory trusts. They're one and the same. Delaware statutory trusts are formed as private governing agreements under which either property, real, tangible, and intangible, is held, managed, administered, invested, and/or operated, or business or professional activities for profit are carried on by one or more trustees for the benefit of the trust or entitled to a beneficial interest in the trust property. Statutory trusts have been recognized by the Delaware common law since 1947. Quote, Hale goes on to say, quote, Brandon and Clint need to consult with Weiss Law Group in Paris, end quote. No, I actually don't. A supposed law group in Paris? Unless I had a foreign trust that was a French trust, managed by a French trustee, then sure. I would get a French law firm, not this supposed French law group, which is not an actual law firm like they try to sound like. And what he says is a law, no, that's a lie. But that's not what people are doing, nor should they. They're not setting up French trusts, right? If you're setting up a trust and you're in the States, but you try to say it's a foreign trust and it's managed by a trustee who is also in the States, then your trust is in the States. It's not a foreign trust. If you try to go offshore and evade taxes or regulation, see how that works out. Look at the Panama Papers and what resulted from that. Those people doing exactly that. Lots of people went to U.S. tax court and lost because with offshore trust, now you're under surveillance of FinCEN, who does not mess around. Okay, so Weiss and Associates. What is this? Well, it was founded or ran by a guy named Stedman Jackson, who's now gone. Okay, so these guys allegedly operate out of France, although there is no proof of that, and it actually is very in tune with the sovereign citizen movement gurus. They're pushed by Bobby Lawrence, David Straight, KL. So, what does this group say? Well, they say that they purport to help clients permanently leave the U.S. tax club. They say they will help you file a petition in the U.S. tax court and guarantee 100% that they'll win you a dismissal or money back. They claim a dismissal allows you to no longer have to pay income tax. Now, first, they guarantee that a dismissal for lack of jurisdiction in the U.S. tax courts and claim that this means they can't tax you. But they're selling this to people who have never read a legal opinion in their lives. Well, because they're not easy to grasp. They even link one of their dismissals. What these clients don't understand is the dismissal means that they lose. The linked document literally says something like dismissal for lack of jurisdiction for failure to file correctly. But for every 10 people that understand that, I'm sure that one person does not. They are no different than any other abusive trust guru selling packages, okay? They think getting a petition to the tax court dismissed is a win against taxation. Well, I hate to say it, they are selling dreams, as great as it sounds. They sell the dream that not one document is sufficient to confer jurisdiction over the court. That sounds great to people who don't know how tax court or the IRS actually works. The court's jurisdiction, a notice of deficiency, is not the same thing as the IRS jurisdiction to go through the assessment and collection periods of an audit. If you try to go to the tax court every time you have an issue with the IRS, that's not going to work because tax court only has jurisdiction to review certain IRS determinations, like notice of deficiency and determination after the collection due process hearing, if you follow proper timelines and procedures. So gurus like Weiss or others selling the dream that they have the secret way to get a court judgment that displays IRS has no jurisdiction because they file a sham petition and then trick people into thinking the dismissal means they win against the IRS, when it doesn't mean that. They also sell the revocation of election paper, which Clint and I covered in our last video. ROE does not work in the context of what these gurus are talking about. Not a single one of the gurus pushing the revocation of election with the IRS ever seemed to have any evidence that the IRS accepted their revocation. And the only proof of success has been claims from people that they haven't heard from the IRS ever since they sent the IRS the ROE. But that isn't proof of anything other than how slow the IRS.
Well,
it appears.
We've also talked about how the reason they send it to certain offices is because the workers are not allowed to say, "Hey, oh, this is obviously fraud. I'm going to put it aside." They're required to file what you send them. So they say, "Don't send it to the proper office because they'll actually challenge it. No, send it here where they know it's going to get filed. It's going to go into some file, and it's not going to be found for 5, maybe 1, but probably 3, 4, 5 years, maybe 10 years. When all of a sudden you get this massive tax lien on your property, and they take your estate to pay for what you did 10 years ago that was completely fraudulent. It's either that or what, go to jail or right. So the important part, as I said, is they tell you to send it to a certain office because they know that that particular agent that you're sending it to has no power to challenge it. They're required to enter the paperwork without question, and they don't touch it again. It's gone until someone finds it later on, right? And then they tell you, well, if they don't respond, then it's such bullshit, man.
It is. And it actually appears the IRS is starting to clamp down on this revocation of election. Some people, I have been informed, that did this, who sent the Form 56 revocation of election, received from the IRS what's called a 3175 letter from the IRS warning them that that correspondence they sent is based on frivolous tax arguments, which the IRS has a whole page on. Just look up IRS frivolous arguments, okay? And then in this letter from the IRS, they tell you that the IRS will not respond to further correspondence making frivolous arguments, and in that IRS failure to respond means that the IRS aggressor accepts or acquiesces to such argument. So if you were to send a revocation of election letter for a collection due process hearing or an offer in compromise, this document could be penalized by the IRS for $5,000 as a specified frivolous submission. Okay, that's what they call it under our IRC section 6702. So the IRS sending a 3175 notice in response to a revocation of election letter, in the IRS's perspective, that establishes evidence that you were warned that your Form 56 letter is, well, frivolous. And so the IRS, they're going to penalize these documents without warning or giving you a chance to withdraw the frivolous document to avoid the penalty. So just realize the can of worms you're opening if you try to mess with this stuff. You see, the fundamental flaw with the revocation of election, ROE, approach lies in the inability to rescind a choice that was never formally made. Even if the IRS were to recognize an ROE as evidence of non-resident alien status, this designation alone does not grant immunity from tax obligations. Establishing non-resident alien status through an ROE, even if feasible, does not equate to exemption from income tax, as outlined in IRC 871. A legal precedent, Walby versus United States, the court found that the plaintiff, Walby, failed to prove her non-citizen status, dismissing her complaint due to the lack of valid claim. Arguments relying on passport renewal as proof of non-citizen national status were debunked, as the State Department's letter explicitly stated that Walby would be issued a U.S. passport affirming her U.S. citizenship. So it's crucial to recognize that challenging the IRS's jurisdiction, especially during collections, is impractical. The focus should shift to addressing the actual tax liability, evident through ongoing collections activities. So you wouldn't be in the collection period if they didn't have jurisdiction in the first place. I mean, make that argument make sense. So claims of lacking jurisdiction do not negate the existence of tax obligations that warrant collection efforts. Okay, so here we got a IRS response to a revocation of election letter. But if we look at the letter, read what it says, notice it starts off by saying, "Dear taxpayer." The IRS starts this out by saying, quote, "We reviewed the information you provided and determined no action is necessary on your account," end quote. So notice they said you were a taxpayer, and nowhere in this letter did they say the taxpayer doesn't have to file. A revocation election will be used against you as evidence later in tax court, which we've seen happen to plenty of people. And the IRS will send you a letter saying that this is frivolous, the ROE. You're literally walking into a trap with that, guys. Okay, so then KL says this, quote, neither meaning Clinton and I, knows the difference between a private and public trust, end quote. Okay, but he doesn't make clear or define the difference at all, or show any actual legal definitions of that. It's just subjective interpretation. So we covered that. Any trust designed for the benefit of individuals, that's a private trust, unless you're forming a charitable trust. No mention of this whatsoever from these gurus. By the way, you go on their little website, there is no proof they're in France. All right, I don't need some alleged French a-hole to tell me how trusts in the States work. KL later in this video, he divulges his favorite gurus that he learned from. He says, I learned from Winston Shrout, Robert Menard, Brandon Alexander, Gordon Hall, Eric John Phelps, Dean Clifford, and his brother. Winston, all you gotta do is look up Winston Shrout fraud, the rise and fall of a sovereign citizen guru. Look at this. Office of Public Affairs, fugitive and tax fraud promoter captured and set to serve his 10-year prison sentence. United States Department of Justice. Gordon Hall. Hall versus United States. Look at this, guys. Does this look like this guy knows what he's doing? Alright, now he mentions Eric John Phelps. Let's look at this case. Pro se plaintiff Eric John Phelps initiated this action by filing a complaint on January 13, 2022. Okay, so this is pretty recent. Against defendant Secretary of the Treasury, seeking, quote, a full accounting of all trust property administered by the Secretary of Treasury trustee being held in the name Eric John Phelps, all caps by the way. Federal ID number blah blah blah. The trust, document 1. After paying the required filing fee, Phelps filed 3 petitions and motions to seal this case. Phelps also filed a motion for the court to order service of process by a marshal of the United States, and a motion for the court to send Article 3 judicial power to provide civilian due process of law in old American exclusive equity jurisdiction and chambers. It's just like KL was talking about earlier, right? And this is a real life example of someone trying to do this. He says, for the following reasons, Phelps' motions shall be denied. So guys, you just gotta read this case and see that not only is this one of his favorite mentors that he supposedly learned from, it doesn't know what he's doing, but also proves everything that KL is saying about Article 3 and Court of Equity. It doesn't work. Motion for the court to set in Article 3 judicial power to provide civilian due process of law in old American exclusive equity jurisdiction chamber. Alright, so look at this. Phelps versus John and Jane Doe's 1 through 99. Cause of action. 42 U.S.C. Section 1983 Civil Rights Act. Now, a lot of these gurus love to use this as a cause of action, as if a lot of these things are civil rights cases when they're not. All right, so let's look at this case. Receipt of payment from Reformation Bible Trust. Oh, so he uses a trust to pay for the filing fees of this case. Okay, so he's just showing to the public, here's my trust, guys. How dumb is that? In the amount of $400 for civil filing fee. File 8, motion for extension of time to amend complaint by Eric John Phelps. Attachments number 1, proposed order. Filing 9, order findings as moot. Number 8, motion for extension of time to amend signed by Magistrate Judge Joseph Saprito. Filing 10, motion leave of court to proceed in exclusive equity jurisdiction within the court's Article 3 judicial power. So here it is. He's trying to do this again. Filed by Eric John Phelps. File 11, order finding as moot. Number 10, motion for leave to proceed in exclusive equity jurisdiction signed by Magistrate Judge. File 12, motion for leave of court to sit on Article 3 judicial power by Eric John Phelps. So he tries it again after I already failed. Filing 13, order denying is frivolous. Number 12, motion for leave of court to sit on Article 3, judicial power signed by magistrate. So he tries it again. File 14, motion for reconsideration. Number 13, order on motion for leave of court to sit on Article 3, judicial power by Eric John Phelps again. File 15, order deny number 14, motion for reconsideration signed by magistrate judge. So you can see how this guy just flips around and flops. I mean, he's tried it multiple times. Does not work. And then Dean Clifford, do we really have to get into that? The guy who's been arrested multiple times? Let's not learn from successful court cases. Let's learn from career criminals. So I think I have some background for some ability to do these kind of things. That's a quote from KL. Quote, I've never had one of my trusts be quote-unquote sham trust by the IRS. We give them 30 days to disclaim, end quote. Oh my gosh, so he's another one of these gurus that, hey, if you don't respond in 30 days, it becomes law. Well, first of all, you're not a lawmaker.
Periodically, that somehow if money gets funded into trust, then therefore nobody pays any tax on the money. Well, okay, you got to take 2 steps back chronologically. First of all, you're talking about money that you earned, that you're then trying to stick into the trust, and we don't allow you to do that and escape paying taxes. We have this very nice doctrine that was created by the courts called the assignment of income doctrine that basically says if you earn income, you must pay tax on it. You can't just shift it on to somebody else. So even if, let's just assume hypothetically, this is not true, but just assuming hypothetically that the trust did not have to pay any taxes, the assignment of income doctrine would say, nope, that doesn't work.
Just register everything in the trust and there isn't going to be a problem. When you don't have to pay taxes and you get 100% of your check, boy, let me tell you, that's a whole different game.
That's a whole different game.
So he says register everything in the trust, and then you'll avoid taxes, but trusts are actually taxed at the highest rate. In the States, it's 37%, in Canada, it's almost 50%.
So sometimes people get confused because they hear the DNI or distributable net income, and they'll hear like, hey, the trust is sending it to the beneficiary. That doesn't mean that nobody's paying tax on it. It just means the trust doesn't have to get killed on at the highest level, and it's taxed to the recipient.
True.
That's not what these guys are doing, though.
No.
But you see, he's telling you, leave it all in the trust, and that way it's not taxable, when it could not be further from the truth. In fact, you are implicating yourself into the highest tax rate possible.
Brandon did mention that he tried to read Art of the Passing Buck, Book 1, and he dismissed researching who these individuals behind the trust were that wrote the book.
The IRS determined that the trust should be disregarded.
They defended that book against the IRS, and I believe the Department of Defense.
You go on the Art of Passing the Buck website, and it says victory over DOJ. Oh, sounds great. After a legal battle that lasted over a year, the Honorable Judge agreed that the content of these books does not violate tax laws and is protected by the First Amendment, therefore refused to ban these books. Okay, first of all, this is complete falsity. All right, so here we got the original complaint from the IRS. Now, of course, if you know how the structuring works, basically the IRS uses DOJ for their policing power, making a complaint against Gwen Wyckoff and Frank Ozak, seeking a permanent injunction in IRC subsection 7402, 7408 to prohibit them from further promoting a fraudulent tax. Now here they are listing the jurisdiction on this court by 28 U.S.C. Venue is proper in this court pursuant to 28 U.S.C. subsection 1391 and 1396 because defendants Gwen Wyckoff and Frank Ozak are residents of Los Angeles, California. So now they list that these two were involved with a fund, an organization through which the defendants have in the past promoted their illegal activities. We're talking about Mr. Ozak here. He had previously represented himself on business cards and in biographical descriptions posted to the internet as an attorney, although the California Bar Association does not list him as he admitted to practice in the state, nor does he appear to be admitted in any other state. Wyckoff acts as a trust administrator or protector for several of the abusive trusts described in more detail. Both defendants are heavily involved in the promotion, creation, and operation of the abusive trusts. As described in greater detail below, the defendant jointly advised individuals and business operators about the benefits of establishing abusive common law trusts, which they falsely claim will allow their customers to avoid the payment of federal income taxes. The trusts they help create, and also in many cases directly assist in the management and operation of. Wyckoff and Ozak frequently act as paid trustees for the trusts they urge and help their customers to create, and thus provide more than mere upfront assistance in the creation of trusts. Here's where it gets really weird. So through management of the taxpayers' assets and funds, the trusts purport to distribute their income to certain named beneficiaries, to make it appear as if the trusts have no resulting tax liability. Such beneficiaries, however, prove to be illusory. Offshore entities with falsified addresses that are merely intended to create the appearance of legality. Falsified addresses with offshore entities. I mean, that's as obvious as you can make. Ozak and Wyckoff represent two customers that the creation of such trusts allow individuals to legally avoid federal income taxation, because the trust, rather than the taxpayers, own and control the trust. The defendant's customers either do not file income tax returns or file returns that suggest they have little or no income. The trust tax returns similarly show distribution of almost all trust income to other entities and thereby claim no income. In fact, however, these trusts are simply the linchpin of an elaborate scheme to evade the payment of federal income taxes. In all instances, customers of the defendants who have created such trusts continue to exercise control over the trust. See, that's the problem there. So they pitch to their clients, well, you own enough control everything like this. Okay, but then they're having their customer still controlling the trust, the assets, and the property. They have created such trusts, continue to exercise control over the trust, assets, and property. Now again, this is fine if it's a irrevocable trust, and they don't put it on the radar by funneling money through offshore entities, filing really weird returns. I mean, you're doing everything you can to raise red flags. In all instances, customers of the defendants who have created such trusts continue to exercise control over their trusts. And again, that's fine and stuff revocable. But what these guys are set up always is irrevocable in these trusts and clients that they're going. How can you own nothing, control everything, but then still control everything? Like these guys are doing. So it's unbelievable. And merely the legal fiction of the trust to create an illusion that they have no taxable incomes. So again, the whole point of using an irrevocable trust is, yes, you do want to have it so that it is not your asset anymore. You do want to have it so that it's lawsuit proof, but that doesn't mean that makes it tax proof. Now they're talking about how they used to get their customers. So they do so through personal appearances at meetings of like-minded individuals. Oh, okay, so like the guru seminars at a motel, right? Web-based publications and the sale of 2 printed volumes they helped write under an assumed name, right? So if you ever read that book, you might have thought that was one person writing it. Turns out it was 2 guys using pen names. Both volumes of which are replete with false statements about the taxability of trusts and other income. They have gone so far as to take retaliatory action against employees of the IRS who are tasked with investigating the defendants and their schemes by filing frivolous administrative actions or lawsuits in order to deter investigations of their illegal conduct. Now, here's the really interesting part, and then specifically advise their customers not to cooperate in IRS investigations as well. Okay, in the light of the above, the United States seeks a permanent injunction prohibiting Wyckoff and Ozak from promoting the creation of these sham trusts. So yes, they are calling these types of trusts shams. I never made up that term. Promoting the creation of these sham trusts and making false statements about the taxability of the trusts. Okay, so then they list all of the penalties they're under. The defendants appear to have first latched onto the use of common law trusts as a means of tax evasion, after they personally created for themselves the Kensington Fund, an entity that itself was a common law trust and that they used for tax evasion, as well as an organization through which they initially promoted their ideas. So there we go. It turns out this private common law, private business trust isn't so private anymore when you have to deal with. These 2 entities were both vehicles through which James A. DeLulo was permanently enjoined from promoting tax avoidance schemes based upon fraudulent trusts, and is currently the subject of a bench warrant for his arrest for violating the terms of his injunction. Based on part of that determination, the IRS made a jeopardy assessment against the Kensington Fund of $56,734 as of April 30th, 2010. The Kensington Fund owes unpaid taxes, plus penalties and interest in the amount of $105,000. So, you think the $100,000 is bad? Well, just wait, because literally worse. In 2008, the defendants published and began to sell a 2-volume work entitled The Art of Passing the Buck, which contains numerous glaringly false statements about the Internal Revenue laws. So, look, I'm not saying, I'm a fan of the IRS with all this, but the second you start doing this stuff, you're inviting it. Anyways, as we can see here, Wyckoff and Ozak also spread patently false information about the IRS in books they promote. For example, they claim in The Art of Passing the Buck, the IRS is a foreign organization based in Puerto Rico and not part of the US government. Most problematic, the book falsely states the IRS has no authority to collect money and that federal agents have no jurisdiction over common law trusts. So, here they are, having to deal with all this. I mean, imagine being the guru saying all this, and then you're literally dealing with what you said wasn't possible with common law trusts. The book falsely claims that the IRS cannot obtain records without a search warrant, when in fact, the IRS can lawfully request records through civil summonses that can be enforced by court order if necessary. The books further highlight several factors that the IRS considers in determining whether a trust is a sham, but ignore a fundamental requirement for a valid, irrevocable trust, the true relinquishing of control over the assets placed into the trust by the taxpayer. In this respect, the works utterly fail to mention a transfer to an irrevocable trust is invalid for tax purposes unless such control is relinquished. It instead advocates that customers merely take cosmetic steps to create the appearance of a relinquishing of control. Well, there we go. They didn't even follow what they said they would do. Own nothing, control everything. They don't even know what that means. So the Art of Passing the Buck also falsely claims that the instructions that the IRS provides taxpayers regarding the taxability of trusts is incorrect. It incorrectly states that distributions of trust income are deductible distributions of tax, to the point where little or no tax is due from the business trust. The books neglect to mention that distributions are only deductible if the trust documents require that all income be immediately distributed, or that distributions of trust income are taxable to the recipient. Now remember, on their website they were lying. They said that the judge said, well, this is protected by free speech. Well, in here, if you actually read the case, they say, rather, they constitute false, intentionally misleading, and or deceptive commercial speech that this court may regulate, if not ban, entirely. These statements all propose a commercial transaction, that taxpayers not merely set up common law trusts, but purchase at considerable cost The Art of Passing the Buck book, which used to be $400, by the way, and then directly engage Wyckoff once the trust has been created as described in greater detail below. There you go. Man, does that sound like a guru? They sell you the information that you need to even understand what the hell they're talking about, and then they upsell you on the, hey, well, now if you want the trust, I'll give you the trust, now that you are taught the wrong way about trust. And by the way, later in this case, it was found by the judge that this was not protected free speech. What they were doing, they considered it commercial, transactional speech, which is not protected. Wyckoff and Ozak assist their customers in the creation of such trusts, even though Ozak and Wyckoff's customers frequently continue to have control over the assets income. Once created, the defendants act as trustees for the trust and hold other supervisory or administrative roles. So this is where it gets pretty shockingly bad. So Wyckoff and Ozak falsely tell their customers that this arrangement is beneficial from a tax standpoint because individuals do not pay tax on income they receive that is paid directly to a trust. In actuality, individuals are responsible for income they earn. Wyckoff and Ozak also arrange through third parties, Mr. Dilulo most often, for the preparation of income tax returns for the trusts they help create. Such tax returns claim the grantor's salary and other amounts as deductions. On their individual tax returns, the trust grantors routinely fail to claim the amounts they receive from their trust income. In turn, the trust returns report that the trust has distributed all of their income each year, negating any trust tax liability as well. However, when the IRS has investigated these distributions by attempting to trace the funds at issue, it has consistently discovered either that they did not in fact occur, that no money was in fact distributed, contrary to the claims in a trust's tax return, or that the distributions were made to other trust entities, upon examination, turned out to be sham entities. Alright, so now they're talking about another client of theirs. They convinced the client transferring all of his personal business activity to their trust, meaning that all business now is going to be conducted under a trust. Prior to the creation of the trust, Mr. Wilson reported that the income he derived from his business practices on Schedule C appended to his personal Form 1040 income tax return. Wyckoff and Ozak subsequently prepared the trust documents, created trust bank accounts, because remember, they act as trustees for these guys, and did other work to set up several trusts on behalf of Mr. Wilson. Wilson agreed that Ozak and Wyckoff would serve as trustees. One trust was to receive Mr. Wilson's business income, issue checks for his individual salary and for his business rent and expenses. The second trust was established for the purpose of owning all of Wilson's personal assets, a step which Wyckoff and Ozak said would insulate Mr. Wilson from creditors. And sure, irrevocable trusts do protect your assets from creditors. However, it doesn't all of a sudden flip your tax liabilities into non-existence. Wyckoff and Ozak informed Mr. Wilson that he would realize tax advantages from the creation of such a trust. Once the trust had been created, all income and expenses reported in connection with Mr. Wilson's business were reported on fiduciary income tax returns Forms 1041, filed by the Anna Corey Family Trust. Mr. Wilson was that trust general manager. So, see, there we go. The grantor was the trust general manager? I mean, make it make sense, people. Because they tried to make this into a business trust, they thought they could have, corporate-like roles that Mr. Wilson could fill in. So they're so sneaky. They're like, well, we won't make you trustee because that'd be, maybe the customers would catch on that we're setting up a sham trust. So we'll just make a position. We'll call it the manager, the general manager of the trust, which doesn't even make sense because the trustee is the fiduciary. You don't need a general manager in a trust. But I get it. They were trying to do the business trust scam. And he continued to operate his own business. After 2003, however, Mr. Wilson ceasing filing a personal Form 1040 income tax return and thus did not report his own salary income derived from his business activities. Okay, so see, now he's got all of his business going to the trust that he has control of. I mean, he would have literally been better off with just having his business stay in a limited liability company or something. Mr. Wilson submitted payments he received from his patients directly to the trust. Okay, so imagine doing business with the world. Okay, maybe you're a mechanic or a locksmith. I don't know. But you're having everyone write checks out to a trust. The trust thereupon paid Mr. Wilson a monthly salary. Oh, see, there we go. I mean, what the heck is going on? So, he's doing business under a trust, which just looks weird. The trust thereupon paid Mr. Wilson a monthly salary. Again, that looks weird. As grantor. You literally are just showing that you created this trust all for your benefit. It wasn't intended for estate planning purposes, that's for sure. It wasn't intended for asset protection. It was intended for avoiding taxes and self-benefit. Ozak used money deposited with the trust to make at least 2 investments that they later informed Mr. Wilson had been so unsuccessful that the sum of the investments was completely lost. So there we go. Imagine having these 2 assholes as your trustee in your trust, and then they take on the role of the investment advisors. So now they just choose to throw your trust money into some investments that you don't know really too much about, which one of the other cases in this they mention. They tell them that They tell their clients, it's better if you don't know where I'm investing this money. Then it gives you more innocence in any type of investigation. I wonder why they're planning for that, right? But even then, that didn't really do what they thought it would accomplish. So, sure, they tell their client all the money is gone, the investment went bad. Did they take the money out? Wyckoff and Ozak also informed Mr. Wilson that the trust could take deductions on their income tax returns that an individual could not take on his personal tax returns. They informed him that they would arrange for the preparation of the trust tax returns. Hey, can trust have deductions? Sure. Just like a business can, right? A business, although a business has more deductions it can make than a trust. So, anyways, they're milking the trust write-offs, basically, taking it way too far. Even though these trusts were ostensibly created for Mr. Wilson's benefit, there we go, the defendant designed the trust to benefit them personally as well. The defendant's talking about these two brothers, are the passing the bucks authors. One of the trust documents states that Mr. Wilson was to be fined $100,000 for discussing trust information with others, a provision intended not only to benefit themselves, but designed specifically to keep Wilson quiet about the Anna Corey Family Trust. This is the trust they're setting up for him, were he to be contacted about the trust by the IRS. There we go. $100,000 fine, but don't worry, it protects you from the IRS. Okay. In addition, another document provides that if the trust were dissolved, Ozak and Wyckoff would get 51% of the assets or funds in the trust, rather than the customer, grantor, or beneficiary who were the source of the trust assets to begin with. I mean, look at these shysters. The IRS examined the tax returns for the Wilson Trust for the 2005 through 2007 tax years. In so doing it discovers that they all contained false deductions offsetting all of the reported trust income and reporting zero overall tax liability. Mr. Wilson had never seen, nor had he signed, the tax returns Wyckoff and Ozak arranged to have prepared. So imagine being blind from all of this. You gotta feel bad for Mr. Wilson here. Indeed, he only had learned that the IRS had opened an audit to investigate the trust's tax liability when he personally received a summons. After an audit and examination of the Anna Corey Family Trust tax returns, however, the IRS determined that the trust should be disregarded for tax purposes. So there you go. They saw it was a sham trust, so therefore, they don't even see a trust. That's the problem with these sham trusts. So you can say all day, oh, the IRS has never called my trust a sham, but here we are, very similar Trust Guru Trust, and here we go. Like I said, the IRS will not even recognize it as a trust when they figure it out as a sham, because you're not using it for a trust purpose. You're using it for personal benefit. The whole point of a trust is for other people's benefit. Now, can you benefit out of a trust while you're alive? Sure, but not make it look like this, right? Both because the trusts were sham arrangements with no economic substance, but also because they were grantor trusts whose income was taxable to Mr. Wilson individually. Notice that they called it a grantor trust because the grantor still controlled it, being the trust manager. All right, and then the IRS, they calculated the tax liability. It was tons of money. As of April 30th, 2010, the total amount of tax deficiencies assessed in these four cases involving Wyckoff and Ozak's promotion of common law trust is $1.192 million. And then we get to the permanent injunction. As you can see, the defendants go along with this. They say, you know what, you do have jurisdiction over the IRS, so looks like they changed their minds. And then, yeah, they get their permanent injunction. They cannot work on anyone's trust ever again. They can't promote lies about taxes. And they can't operate their little Charles Arthur Enterprises Trust anymore. It is ordered, dated September 08, 2011. So there you go. I don't know how you could call that a win. But I guess I got to do better research, right?
When we write these trusts and we send them to the government, we give them 30 days to disclaim. So we give them the opportunity to say this is fraudulent or this is wrong.
Again, like as if you're some lawmaker by mailing documents. Another quote from him: if you claim to be the beneficiary before anyone else does, you have to be by default the trustee. Oh, wait a second. So remember, in this context, he's talking about implied trust. That's what he's always so excited about, right? So then he says, so you had to be by default the trust, but remember, implied trusts do not have trustees. And he doesn't even know that. But the other way is if you claim to be trustee by saying yes, which means, who are you going to pay? Dude, what does this even mean? And again, this is quoting him verbatim. This is all about trust law. And that's what's going on in the courts to this day. No matter he or Robert thinks. Yeah, he thought my name was Robert towards the end. But Rice had to do a little correction. It was kind of awkward. No matter what. So he says, no matter what. No matter what? Where's your proof of this? Again, no written law or past case that can prove this. And then he gets into common law marriage. He says that the state will recognize you as married, but not yet every state has common law marriage. He says it's because of your actions. Quote, because of your actions, end quote. Another one, quote, doesn't matter if they have a contract or not, end quote. Quote, it doesn't matter if you have something in writing. Your actions dictate in trust law, end quote. Yet can't cite any law saying this about his context of implied trust. Your trust does not have its own enforceable trust law if it's not in writing, first of all. Second of all, the only time implied trusts are enforceable are by judges in court, not some a-hole going into court as a defendant. Plaintiff, whatever you are. Of course, KL, he loves his DBA, just like all these other gurus. Using a DBA is you as the individual, though. He tries to act like it's some separation, right? But it's still you as the individual, which is the straw man, what the law considers a natural person. So people hear natural person, they say, oh, that sounds great. But yet they don't realize the straw man is what they call the natural person. DBA that is not attached to another entity is still you legally, not a separate entity. Unless the DBA is for a separate entity like a limited liability company or a C Corp. Okay, something like that, sure. But a DBA for a sole proprietorship, that what he makes you use? That's not a separate person. A sole proprietor is you. There is no separation from the liability and the debts in a sole proprietorship, right? Same with the liability protection. There is no liability protection because it's you. You, the straw man. Okay, so using the DBA is you, the individual. Let's get that very clear. What the law considers a natural person, the straw man is what they call the natural person. So what is the legal definition of doing business as? Doing business as is a term referred to a business's assumed trade or fictitious name, indicating that a business is conducted and presented under a name other than the legal name of the legal person or persons who own it and are responsible for it. Okay, so it would make sense if he used the DBA for an LLC or something, right? Where that is an actual separate business entity. It's a separate person. But no, all you get in his package is a sole proprietorship and a DBA when it comes to the business side. Not a separation from the straw man. Sole proprietorship is a form of business entity in which one person owns all the assets and assumes all the debts of the business. It is also referred to as proprietorship or individual proprietorship. The owner of the proprietorship is called the sole proprietor or the proprietor. The sole proprietor is the simplest entrepreneurial structure and does not require any formalities to be taken to form it. So it's still going to be you, it's just that you can use a little nickname in it. That's it. This status will automatically come from the proprietor's business activity. There is no distinction between the business and the proprietor. See, there we go. There is no distinction between the business and the proprietor, who enjoys full control over the sole proprietorship and is entitled to all profits, but is subject to unlimited liabilities for all losses, debts, and liability of the business. Again, guys, do you want unlimited liability? Like this is it literally says subject to unlimited liability for all losses, debts, and liabilities of the business. Guys, there is no asset protection with this. There is no lawsuit protection. You are 100% on the hook. Alright, so there's also no separate income tax. See, there you go. To be paid for the proprietorship. And all losses and profits are reported on the individual's tax return. Okay, then here's another quote Kale has about the corporate soul, which I've talked about in depth. These tax protester trust gurus, a lot of them are into this corporate soul. So this is what he has to say about it. Quote, the corp soul is created by the state you were born in, end quote. Okay, so where is his proof of this? Oh, his proof is actually that his uncle supposedly worked for the Vatican, and that they taught him what a corporate soul was, supposedly.
And Brandon, I'm going to give you something to actually look up. Pollock v. Farmer, U.S. Supreme Court, 1895, all right, where they ruled that there's a difference between a natural and a private person, because what they tried to do in 1895 was tax the man and woman for income taxes, and the Supreme Court said you can't do that. You cannot tax a natural person, but you can tax an artificial person like a corporation. Okay?
Natural person describes a natural human being, which, I mean, they can call it that, but that's the straw man. Artificial person describes a partnership, corporation, or some other entity that has been provided with legal personhood by statute. Which, again, the alternative movement is terrified by the sound of this. When, in reality, if you're a smart business person and smart investor, you want that separate person. So he's trying to say that the straw man is a corporate soul, right? And that's, again, he just lists a Supreme Court case to support.
Clint and Brandon, I'm going to give you something to actually look up. Pollock v. Farmer, U.S. Supreme Court, 1895, all right, where they ruled that there's a difference between a natural and a private person, because what they tried to do in 1895 was tax the man and woman for income taxes, and the Supreme Court said you can't do that. You cannot tax a natural person, but you can tax an artificial person like a corporation.
His argument, Pollack versus Farmers Loan and Trust Company, 1895.
And there was another gentleman, I get on the phone with them. It's always somebody that they say is a lawyer, but it's not a lawyer.
Yeah.
They know a lawyer, and the lawyer had a Supreme Court decision that they rely on when they said to do it. And I'm like, what's the Supreme Court decision? And then I look at it and I'm like, it has nothing to do with what you just said.
Yeah.
You know, or it's something that is like from 1800s or something goofy where you're like, you know, or a long time ago, 100 years ago.
So the state, under the rules of the sea jurisdiction, maritime law, when your dad leave the afterbirth there, they make a claim on that afterbirth. It's born alive but presumed to die. They give it your name, but in all caps. That is what becomes the corporate soul. Now, according to the Constitution, which he loves the Constitution, it's constitutional that you can tax a corporation, so that your whole life they can never really tax you. They can tax the corporate soul, the corporate straw man. Now, you unfortunately have been tricked to pay it for him. When you sign to pay taxes for him on the 1040, you agree to pay for him because he can't. He's bankrupt. I'll pay it for him, is end quote. He says the corporate soul strawman was placed in a public trust. Congressional Record 1967. A citizen of the United States is a civilly dead entity operating a co-trustee and a co-beneficiary of the PCT, the Private Constructive Cescuve Trust of the U.S. Inc. So there he goes. He tries to use a constructive trust, which we've gone through that. It's not what he's talking about at all. And by the way, we'll go through the Congressional Record here in a second. Nothing in there says what he's talking about. Your mouth. It's on the Congressional Record that the straw man is in a trust. Cescuve Trust of the U.S. Inc. under the 14th Amendment, which upholds the debts of the U.S. and U.S. Inc. It's on the Congressional Record that the straw man is in a trust. If someone is using 10 explanation points, that makes me even more skeptical, right? So it's like he's trying to use these explanation points so that you don't actually go and read the Congressional Record that he's quoting. So you pull this Congressional Record up, June 13th, 1967, page 15641 through 15646, And nowhere does it mention it all the straw man. It doesn't mention trust or that the straw man is a trust. It doesn't mention any of those things. Did anyone bother to actually go and read this? What the fuck? I pulled it up and it had nothing to do with anything Kale was talking about. So he thinks a trust in changing the status and other sovereign citizen myths accomplishes owning nothing and controlling everything, right? And he really misses the point of what Rockefeller was really saying. Rockefeller meant don't own the things, curate things into separate personhood. A DBA, corporate soul, is not separate from the straw man. Black's Law definition, a single incorporated office occupied by natural... There we go, there is no separation there. Rockefeller did much more than have trusts, right? He had companies, he had limited partnerships, he had limited liability companies, holding companies. He did equity stripping strategies, as well as funding his trust properly, which students of Kale learn nothing about. They don't even know what that means. All right, so here's a quote from Kale. Quote, on a driver's license, it's presumed you're the trustee. Again, he's presuming this is a implied trust, which, again, implied trusts do not have trustees. I mean, this just is painful to go through, but we had to, folks. I mean, unless you say otherwise, so we sign as the beneficiary of a trust, which means it's not our license, it's the state's. We're just using it, we have no liability because we didn't agree to anything. So if a cop, later they try to, in California especially, say, but you got that license, you agreed to allow us to take blood, see, if you can see that I signed as the agent of the principal, which means I didn't give you permission. So, my apologies. I mean, this guy talks really strangely, so some of his statements aren't even coherent. Dude, so a lot of this is all about teaching you how to sign things in the public in the correct fashion where you're not putting your liability down when you sign, even though you don't think it's anything. According to trust law, if you're applying for benefits, you're supposed to know the rules yourself. That's where the phrase ignorance of the laws have no excuse comes from. Again, end quote, by the way. Again, vapid proof of any of this stuff. He's literally just storytelling. Now, let's go back to that part he said. So we sign as beneficiary of the trust, which just means it's not our license, it's the state's. We're just using it. And we have no liability because we didn't agree to anything. But yet you did. You agreed to get the license, right? That is an implied contract because now use proves that you agreed to the contract. Not an implied it's not an implied trust, right? Quote, they are not going to use a contract with writing, so they're going to use trust agreements, end quote. They don't have to use contracts in writing because there's such thing as an implied contract. Whereas when you try to say this is an implied trust agreement, it doesn't even make sense. The video continues. The whole time, they shoot the messenger, right? So, quote, Brandon states it's ridiculous to think that a court case is a trust, end quote. Oh yeah, because it is. Now, mind you, he says that it's ridiculous I say that, but yet in this video, he was unable to uncover one shred of evidence that court cases are trusts. Now, I have gone over in a past video a court case where someone was trying to argue this in court, failed, and lost the case. Another one, he says, quote, a charge is a trust, end quote. Well, so let's look at the legal definition, not Kale's words, of what a charge is. And when we look at it, it's just a function of the court. The instruction given by a judge. Okay, so where does this mention a trust? Now, a judge can set a constructive trust, but again, that isn't the kind of trust that most people are thinking about when we're talking about trust, right? And we'll later go through what a constructive trust is. But again, it isn't this kind of trust that most people are thinking about. All right, he says, now a charge may be a financial burden or an encumbrance, lien or claim. A charge is also a fee for services. That's the legal definition. Then he goes on to say, quote, a franchise is a trust, end quote. So let's look at the legal definition of franchise, not his word. Franchise is a contract, not a trust, and is part of contract in business law, which is separate from trust law. It goes on to say, quote, a transfer of property and mortgage are trusts, end quote. Okay, how is a transfer of property a trust in and of itself? A transfer of property is a conveyance. What is the legal definition of a conveyance? Well, here we go. Conveyance is the transfer and assignment of any property right or interest from one individual or entity, the conveyor, to another, the conveyee. This is usually accomplished through a written instrument, most often a deed that transfers title to or creates a lien on property. Some sources of authority consider the written instrument itself a conveyance. Okay, so can you transfer property into a trust? That is what you want to do if you have a trust. But to say the transfer itself is a trust, make it make sense, people. Again, he has nothing to substantiate this. Is there such a thing called a deed of trust? Yes. In some states, they call a mortgage a deed of trust, but it's not the kind of trust that these guys are talking about. Other states just call it a mortgage deed, right? Rather than a deed of trust. So to say a mortgage is a trust is laughable. Let's look at the legal definition. It is a contract instrument to convey a commercial transaction. That's all it is. Now, a mortgage under a trust-controlled holding company, that is a powerful tool for lawsuit and asset protection. And that we do use, and I talk about often. But that's nothing what these guys are talking about. Quote, we use a non-UCC1 lien, which is private, which is a complete 180 of UCC1. I'm claiming my DNA. Does it sound like I'm putting a lien on somebody? No. I'm putting a claim on my own property, my own body right. And putting claims on your own body using the artificial system. Gosh, man. Alright, so anyways. So this isn't KL's breakthrough, by the way. At last, the gurus pitched the non-UCC lien thing. They say you can have a private lien because UCC1 liens are public, ours is private, that's what they say. Guys, a non-recorded lien is not going to be enforceable. In America, we have something called senior lien rights. If you don't have a recorded lien on property, there is no secure creditor. With no secure creditor, there is no enforceable collateral to enforce property rights. The perfection of a secured agreement allows a secured party to gain priority to the collateral over any third party. To perfect a security agreement. See, there you go. So you gotta be the priority collateral over any other third party. That's the whole point of UCC1 secured party. That's why when you get a car on a loan, guess what? There's a UCC1 secured party that, let's say Honda Motor, has on that car until the debt is satisfied. That's just an example of the legitimate use of UCC1. Not like these UCC1 gurus or the non-UCC ones. Now, mind you, the UCC1 gurus are just as bad, right? You cannot put liens on the straw man. That is the whole myth Clinton and I debunked in this video. UCC1 should not be used in the way that gurus teach. In fact, we show that course we're turning down filing fraudulent liens in this video. Look, UCC1 in asset protection strategies, it can be used, but it has to be used by a legitimate business. And the secured creditor, it can be very useful for business, but not for patriot mythology. Now, I have now a handful of former KL students work with me now, and they told me all of the process that KL teaches, right? So it's exactly what I laid out in our first video. He has you do all sorts of crazy stuff, write letters to Tony Blinken and Janet Yellen, trustee, the National Shrine. Look, I went through the whole process. I divulged all, and he's hiding like 80% of it from you guys. You don't know what you're getting into until you go to pay and find out. So, anyways, the common pattern I saw with all of his former students, I analyzed their estate plan, and there was no estate plan. In fact, nothing was funded into any of the people's trusts that he had set up for them, the private business trust. nor were they taught how to fund a trust, or even use it for that matter. What's the point of a trust if it doesn't have any property or use? Look, to understand how trusts work, it doesn't require some secret guru process. People should know everything about what they're getting into before they sign up for something, right? But I've had now a handful of people all saying the exact same things. They're all independent of each other. By the way, in this video, they steal Clint and I's Monopoly terminology. You cannot play Monopoly with the rules outside the game when the other players don't recognize it, let alone play by it. Quote, we reached out to them. I tried the same thing. Tried to get on their show. They refused to respond. They refused to put me on again. Put me on again. Dude, you've never been on our shows. They said that around 9 minutes and 45 seconds, by the way. Then they say, quote, Brandon looks like he's 16 years old, end quote. Koreans don't crack. I'm trademarking that, by the way. People will try to use that. Oh, you look like you're 16-year-old. So whenever someone says that to me, I have to ask, okay, well, how high is your IQ? So here's another one. Quote, or he is a spectrum kid and he has issues I'm not aware of, end quote. Quote, he's a very intelligent sounding kid, end quote. So you go from calling me spectrum kid, 16-year-old to all of a sudden intelligent. Complain about how I refuse to have them on my show. I'm not going to promote people like that I know are pushing what I know to be ineffective in court, what I know to be sham trust, sham processes, tax protesting. Yeah, I'm not going to have that on my show. If anything, I'm just going to display how wrong it is. Second of all, I'm not going to debate these people. You cannot debate liars. Why would you ever debate a liar? That is the dumbest thing you could do. Well, guys, if you can sit through all of his stuff, not question any of it, not do the due diligence, and see that I don't have to resort to name calling. I don't have to resort to make bets and assumptions about the other side. No. I'm taking what they say verbatim, comparing it to the primary sources, and in fact, we can see that they double down on lies. So what we just went over was solely about trust, but let me know in the comments if you'd like me to make another video going over the problem areas of his other talking points, such as the political status change, stuff like that. There are plenty of problem areas when it comes to this side of KO as well. So we made it through all that. It was a lot to unpack. If you do the due diligence, you'll actually see that just like I found, these guys are absolutely wrong. Well, that is it for me from now. I will see you next time.